I think there's a lot of misconception out there about trusts.
Mm-hmm.
Why do you need it? What are the different types?
Who
And
needs one?
yeah, what is a trust?
So today we're bringing in the experts. We have Jeff Barnett and Keith Ludy from Barnett and Ludy Law Firm. Thanks so much for being with us.
You're welcome.
Our
Thank you for
pleasure.
having us.
I think a lot of people just throw out terms like, "Oh, you just need to get a trust." It's simple. You just need that. But let's start with just the basics of what's the difference between having a will and a trust.
Well, a will is a legal document where you pass along assets upon your death, and it involves going through the court system, through the probate courts. And so it's really an inactive legal document until you die. A trust is a legal document or a legal entity that you create that can be activated right away and continue even beyond your death. The biggest thing with a trust is that the person who is in charge, called the trustee, has almost unlimited authority over whatever is in the bucket that you've created here of this trust. And it's utilized there's different types depending upon what your goals are. Jeff and I have noticed over the years that a lot of people who move here to Central Texas from California in particular have set up trusts out there because the probate process is so involved and so lengthy. And we always tell them that, well, here in Central Texas, our court system is pretty well streamlined, fairly predictable. Credit to the judges and our court systems here, that many people in Central Texas don't need to set up a trust just automatically the way that they do in California, but they are very useful tools if they're the right tool for your situation.
It seems like there's a misconception out there. I know there was for me that only the wealthy people out there need a trust, but people who are wealthy sometimes don't have one. People who are not wealthy sometimes have one. So it really varies, doesn't it?
Absolutely. Definitely it makes no difference whether you have a small estate or a very large estate, as to whether or not a trust would be useful for you. I mean, if you had a tiny estate, a trust would be ridiculous. But, but outside of that, I mean, if you're talking about a 50,000 estate or $100,000 estate versus a $34 million estate or something, there are people with, multi-million dollar estates that, that really don't need a trust and and we don't always set up a trust, just because somebody has a lot of money.
Right.
It really depends on the objectives and how you're trying to, I guess, give the money away upon somebody's death. Or just
That's right, and not only that, but the need for management during one's lifetime as well, because as Keith mentioned, a revocable living trust or a family trust is something that you set up, now, and you fund it now, and it becomes the mechanism to manage those assets, right now during your lifetime, and then it continues, beyond your death as well, for some predetermined, length of time or until some event. And anyway, yeah.
Hey, I was just going to say, people say, get the trust so you avoid probate, but you still need a will even with the trust, correct?
Definitely, yeah. You always have to have a will, even if you have a trust, and that's also something that that a lot of people don't understand. Well, why do I need to get that if I've got this other?
Right.
And that is because of the thing that happens a lot. Is that something accidentally gets left out, or something. Maybe you put everything in that bucket, at the very beginning, but then you sell something out of that bucket and you replace it with something else, and you accidentally forget to put it back in the bucket. So that's something that happens a lot. I see it a lot. When somebody passes and then their loved one comes in here and says, I think they had this trust. We shouldn't need to go through probate, right? And then we start asking about what's the name on this and who owns this and all of that. And they start checking, and it turns out, oh, there's an account out here that isn't in the name of the trust, or a house that was purchased and it's not in the trust.
Yeah.
Or, as Keith has mentioned before, sometimes, it was just never put there in the first place. Sometimes, the attorney that somebody used, 30 years ago to set something up, set it up for them, charged them a big fee, and then they didn't even, help them get everything into it, all of their assets into it. Sometimes you just, they walk in and you ask, well, so what's in the trust? And they say, I don't even know what you're talking about. So,
Gotcha.
and you start looking in it, and there's literally no assets that are in the trust, and that's very sad.
So you really want to pay close attention to knowing that you have to have a will, and that's, I guess, in some ways that serves as a little bit of the backup if you have a trust, but you still are going to need that as well. So
Yes.
who needs a trust and who doesn't?
Well, who needs a trust is a difficult question because we have to know what a client's objectives are. There's different benefits of different types of trusts. What Jeff referenced, the living trust or revocable trust, family trust, goes by many different names. But the two main benefits of that type of trust, and that's probably the most common type, are first of all speed of distribution of assets, because even under ideal circumstances, probate's at least a 3 or 4 month start to finish thing. Whereas if you have assets in a trust, person passes away and you can dump out the bucket and just start distributing assets immediately. The other big benefit of a trust is privacy, because people don't always understand that when you probate a will, the court keeps that will and it's filed as a county record for all of for all of time. And so it can be searched online and people can find out, oh, here's how you distributed your assets. Whereas a trust is a private legal entity, and so it is not put in any public databases. And so Jeff and I have both experienced people coming in to set up a trust just based upon the privacy issue alone.
Right, and sometimes that's privacy in the context of probate, as we've been talking about so far. Or once in a while, we have a situation where somebody wants to set up a business, and for some asset protection, but they don't want their names in there. And so sometimes when you file something with the Secretary of State, when you form an LLC or a corporation, if you put your name on it, that discloses to the public that you own that business. But if you create a revocable living trust that's anonymously named, it's just called the XYZ Trust or something very generic, as opposed to the Barnes Trust or the Barnett Trust. Then basically you're not telling anything about the owners, and you've got this trust, that then is the registered owner or the managing person of the trust of the business entity, and so your privacy is not compromised in that way.
Gotcha.
Definitely, if you're a celebrity or if you win the lottery, first thing you need to do is set up a trust and name it something totally unrelated to your name.
Yeah.
Got it. Okay.
Remember that when we win the lottery.
Remember,
That's
right. Right. Okay. So that's a revocable trust, and a revocable trust can be changed.
Definitely a revocable trust by its very nature. It is set up, the way I've explained it to people is a revocable trust would be similar to if you wanted to set up a tent in your backyard and pretend that you're camping. You can put it in one part of the yard and the next night move it to a different part of the yard. It is meant to be changed as often as you desire to change it. An irrevocable trust, by contrast, is more like building a brick wall. Where your intention is that this is going to stand and we're not going to move it. And whenever I explain that to somebody, of course, they will say, well, but what if? They'll ask that what if question. What if we do need to change it? And I say, well, that's what sledgehammers are for. You can always knock down the brick wall, but it's going to be messy. So you need to put some thought into whether you want something to be very changeable at a moment's notice, or if you want it to be more permanent. And there are certain provisions you can put into a revocable trust that upon the death, particularly see this in spouse, in a case of a revocable trust set up by a married couple, and specifically, probably more commonly when it is like a second marriage, and each spouse has their own set of children, and they want to ensure, hey, if I die first, my kids are going to get what I intend for them to get. My surviving spouse is not going to have the option to go in and change and give it all to their kids. You can have a provision in there that converts this revocable trust, at least partially, into an irrevocable trust to protect your children.
Okay. So is it just in complicated situations where an irrevocable would be the right thing, or is that really where you just need to talk to an attorney to figure out what are my objectives and which vehicle would be the best?
You pretty much need to talk to an attorney. There's also the scenario of a subsequent spouse. And a subsequent spouse could just be, that surviving spouse could end up giving all of it to the new spouse, or maybe they even have kids with the new spouse and they leave all the other kids behind. There's lots of different scenarios, and depending upon the particular the situation of the clients that that we're speaking to, we can customize a solution that works best for them.
So it's not something that we have to decide. We can think, well, I think we need a revocable trust, and then we go and talk to you, and you say, no, for what y'all need is irrevocable. So we trust our attorneys to pick the best trust.
Sure. I've always looked at it like the client that walks in the door saying, I've researched it and I know what I need. We tend to look at that the same way a doctor would look.
I was just thinking this.
If you walked in and said, so doc, look, I've been watching the commercials and this is the medication that I think that I want. And so just write me the prescription. I'll be on my way.
Exactly.
Definitely not a good idea.
And then, and what are some reasons why somebody wouldn't want to get a trust?
I would say when you do a trust, the cost of doing a trust is very similar to the combination of doing a will and probate. But with a will and probate, you're paying for the will up front and the probate after you die out of your estate. The trust, although it's a similar cost, you're paying more up front. And so sometimes people are reluctant to do that. If they don't see the benefit, if speed and privacy are not a big deal for them. Now, when we get into a situation like with Medicaid, and there's other reasons to set up a certain type of trust, then it's not really an option. You either do it or you don't. But
are there other maintenance kinds of expenses or costs that you would want to anticipate down the road if you have a trust?
Probably not a lot of costs, but there are absolutely issues with regard to maintenance. That's actually something that that we run into from time to time, where somebody has created a trust in the past, but then they left something out of it, and so or they bought something later and they forgot to put it in. So you've got to make sure that you stay on top of it and you're diligent in what you're doing as far as your future actions after you've created one.
Okay, gotcha.
You mentioned Medicaid, and we've done another interview with both of you about the Medicaid aspect and trust, but quickly hit on it about how trust can help in that situation as well.
And that's a different kind of trust too, though, right?
Sure. It's an irrevocable type of trust. We call it a Medicaid Asset Protection Trust, and we do quite a number of these. What's different about it is the overall objective. Medicaid is a government-funded program that helps people pay for their long-term care when they need a high level of care. And it is based upon your countable assets. And this particular type of trust, the reason we use this is that it has the ability to convert countable assets into non-countable assets, to make somebody eligible for Medicaid potentially without having to spend down all of their nest egg first.
And I know we talked about it, so we won't go into great detail because we do have a whole other interview on it. But a lot of times that's set up my understanding from learning from you is that especially if you have one spouse who needs a lot of care and another spouse who doesn't need that care yet, and you don't want to necessarily use up all of the family's money taking care of the one, and then you have the other parent that's left with nothing.
Yeah, if you have two parents and one is healthy and one is not, there's a few other steps we would get to before we did the trust, where you can convert the community property aspect to the 50-50 nature of the asset from one spouse to another, and then eventually set up that type of trust on the healthier spouse. Because of Medicaid's timelines and everything. Like you said, we've got a whole other section that goes into detail of it. But yeah, it's the Medicaid Asset Protection Trust is a very specific type that we use that can save folks a lot of their nest egg money.
Yeah. Okay, so that's a whole other topic.
That's
but,
right.
but just to know, for people to know that that's another additional type of trust that is available and may be the right answer in certain circumstances. Yeah.
But the biggest thing, whether you're talking about Medicaid or millions and millions of dollars, if you're not sure, talk to an attorney and trust them that they're going to lead you in the right direction to protect whatever assets you have.
Sure. And one other type of trust I wanted to be sure and at least make brief mention of is what we call a supplemental needs trust. From time to time, we're approached by people who say, look, we've got a special needs child who is reaching middle age, and we are no longer middle age, and we want to make sure they're provided for when we move on. And this is a specific type of trust that you set up to ensure that your child with special needs is cared for while still being eligible for all of the government benefits that are out there as well. And you definitely want to talk to somebody who knows how to do that. Because if you do that wrong, you could wind up getting this child kicked off of their government benefits. So.
Okay.
But it's called either a supplemental needs trust, and some people call it a special needs trust.
And when you are creating that trust or helping your parents as they're creating a trust, you want to make sure that you have multiple trustees, if you will. I guess there's one primary, but then you want to have succession, correct?
Yes, you want to always make sure that whether it's a trust or a will or a power of attorney, you want to have multiple alternates. You want to have a primary person that you've chosen, that you are banking on, that they're going to outlive you, that they're going to be, the one that's in charge. But sometimes that person doesn't outlive you or is incapacitated themselves, and it's always good to have a backup. And it's very important to have multiple backups because things can happen, and so you want to generally have at least 4 backups and you want them to generally serve one at a time in succession. That's our most regular recommendation. You can have people serve as co-trustees or co-executors or co-agents, but we generally recommend one at a time in succession.
And there's a reason that we do too. What I explain to people is, if you needed a ride to the store and you had 2 friends, you would not ask one to work the steering wheel and one to work the pedals. It's very cumbersome, and you're asking for trouble. Just have one of them drive you, and then they have the other one there as a co-pilot.
Gotcha. Okay. Yeah.
You talk about asking for trouble. I know we have some people in our group who don't have great relations with their siblings. When that's the case, is there going to be any animosity because, I'm the trustee and you're not the trustee, or I'm first and you're second? Does it really matter? Does it affect things in the end?
Well, it shouldn't because the person serving as trustee has a legal or fiduciary duty to do exactly what's in the trust. And so, if you've set it up where it goes 50-50 to, or equally, to all of my kids, then by golly, that's exactly what it's got to do. And if it doesn't, then that person in that role, that trustee, can be held accountable for that. But generally speaking, we always encourage people to be transparent. as trustee, because transparency breeds trust. And if you, there's that word. But if you are more secretive, then that is something that can lead to distrust, and so that happens a lot in families, and
Gotcha.
unfortunately.
Yeah.
So I think that kind of the overarching that I've learned is that it whether you need a trust or not may depend on what city, what county you live in, what state you live in, what your family objectives are, and that's where you really just every situation is going to be a little bit different. There's not a one size fits all.
Yeah.
Definitely agree with that.
So talk about it to someone like Jeff and Keith and get some good advice. Jeff and Keith, thanks so much. You've cleared up a lot of misconception here. Thank you.
Yeah. Thank you very much for having us.
Our pleasure.
All right. So it just goes to show that it is helpful, hopefully, to have the right questions to ask, information to be looking for and looking at in your particular situation. But a lot of times it's going to be different. What works for one family isn't always going to work exactly the same for another.
Talk about it. Get that expert advice. If you have any topic you'd like us to discuss, please let us know. Parenting aging parents.